You're listening to WSTU Stuart.
This is WPSL Port St. Lucie.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning. This is Stuart Address for Ask a Lawyer. It is September 2nd, 2022, and we're going to talk today, finally, about contracts. Yes, I know that sounds like a boring, dry topic. Let me tell you something. It's important, and each of you deal with contracts many, many, many times a year. Some of them little, some of them significant. So we're going to try to talk about what's enforceable, what's preferable, what's required, what's permissible. And I'm going to try to do it in a way that keeps you motivated, keeps you interested, tell some stories, usually about some celebrities that found themselves in a bind. And maybe we can both learn from and perhaps sometimes even enjoy their difficulties. So
you're not going to tell them about my stuff, are you?
Oh, I would never. I have taken a lips are sealed vow with regard to your stuff, and I will be telling nobody other than Carol.
That's okay. I think my guy is still in jail. That's okay.
Okay. Anyway, in general, there are two types of contracts. You got written ones, you got oral ones. A binding, legally enforceable contract can be in writing and can be oral, either one. Oral contracts are those agreements that have been spoken, but not reduced to writing. Now, which one is preferable? A written one. But that doesn't mean oral contracts are not enforceable.
Are they, wait a minute, are they legal in a court of law, though?
They are absolutely legal in a court of law. You have to be able to prove the same things as with a written contract, which is why a written contract is easier. You have to prove offer, you have to prove acceptance, and you have to be able to prove the terms of the contract. If you can't, if there's a dispute about material terms of the contract, there is only so much the court can hear in terms of trying to decide what were the terms, which is why it's always easier with a written contract. And also, depending upon the nature of the transaction, certain types of contracts must be in writing under Florida statute. Every state's going to have slightly different statutes. But for the most part, contracts relating to the sale of real estate and contracts that cannot be performed within 1 year must be in writing. And as you'll see, there are good reasons for that. Generally, other than those two types of contracts, oral contracts are enforceable, especially in situations where one party has already performed their obligations under the contract. So let's say you make an oral contract with your carpenter to do some work around the house. The carpenter does the work and then seeks to get paid. And you say, well, I never agreed to that. The carpenter can sue you in court, probably small claims court, and say that the evidence that you agreed to pay him for the work is the fact that you actually did the work. That you knew he was doing the work. You let him into the house. A judge is probably going to find a contract existed. Now the question is, did you agree to pay him $1,000? Did you agree to pay him $50 an hour? What were the terms? Both of you will probably testify. If you or he has any other witnesses, they'll probably testify. And a judge is going to decide by a preponderance of the evidence, 50.1%, who the judge believes. And that side is going to win. Period. And that's, in general, small claims court, when your claims are in front of a judge. If it's a slightly bigger contract, and let's say your claims are in county court and you're entitled to a jury, the jury is going to make that decision. Who do they believe? By 50.1%, a feather more than 50-50. So yes, oral contracts are enforceable, but there is more of a difficulty in proving the terms when you don't reduce them to writing. Now, for that reason, written contracts are almost always preferable. A written document eliminates disputes that deal with the terms and conditions of the agreement. So, to avoid disputes and minimize litigation, the best practice is to get an agreement in writing. That written contract will help ensure that all the parties understand their rights and obligations under the contract. So let's say you're the homeowner in this situation, and the carpenter comes in and says, I'll do that, that, and that, and I'll charge you $250. Doesn't give you an invoice, doesn't give you, a proposal, doesn't give you a contract. Should you say, hey, wait a second, let's write this down? Probably yes. Because what if he does the work and says that you agreed to pay him $500? If nobody else is around, the only way you're going to prove it was a contract for $250 is if you said, hey, let's at least put in writing, you're going to modify the shelving in my closet, do the lights on my porch, install pavers in the backyard, and I'm going to pay you $250. It can be that simple. It can be a one-sentence contract. But better that and never need to use it than to find you need to prove a contract and have it verbal. Most lawyers will give you that opinion.
Yeah, having never been to small claims court, I mean, winning a case is one thing, but what about collecting?
Well, that's a whole nother story, but in general, if you're the one that has to pay, they'll probably go after you in terms of collecting, and there are ways to do it. If you're the one that needs to be paid, well, you're probably going to have to hire a lawyer because they can stall for years and you'll never figure out how to force them to pay unless they willingly pay, because the ways to enforce a judgment, which is what you get, are varied and complicated and are filled with landmines. So you may win, you try to enforce it on your own, you step on a landmine, you blow off your leg, it's not worth the $20 you just won. So, we can have a seminar on how do you enforce a judgment that could span multiple shows. And obviously, if anybody has any questions about that, I'm happy to try to answer them. And call the station 340-1590, and we can chat. But in general, they're collectible, and usually they are done voluntarily, because if you have to hire a lawyer, then they're going to have to hire a lawyer, and they're going to have to spend more money defending. It's usually not worth it in small claims court. In larger amounts, there are parties who will do their best to avoid payment for years and can get away with it, especially if the other side is without an attorney. So, as we said, there are two types required to generally be in writing, but it's best if most are in writing. What about handshake deals? Good old handshake deals. Well, hey, those are verbal contracts, oral contracts. For the most part, they're perfectly enforceable, but they're dangerous.
Back in the day, when I was
In
working,
the 1800s,
yeah, close. When I was working in a record store, this is in the 60s, and the guy who I worked for actually did a handshake deal with the brand new owner of the shopping center in Culver City, California. And that's all he ever had with that guy. And he was there for about 20 years. It was amazing.
and you make a good point. There are people who are true to their word in a handshake deal. Indeed, there are still people who will only do a handshake deal because they believe so much in the value of their own word, and they trust sufficiently in the value of your word. Sometimes that works out very well. If you're not bargaining over the minutia of a 50-page contract, there's much less chance for you two to get into a disagreement. However, that assumes then that the handshake agreement doesn't run into problems down the road. If it does, then it was foolhardy for both of you to rely upon the handshake deal. If it doesn't, then you probably did a much better deal, and you are much better in terms of the relationship you have together than if you're solely bound by a written contract. But these handshake deals can be difficult to prove in court as to what the terms were. The more complicated the deal, the more difficult it is to prove. And let's just, compare buying, a handshake deal to, buying Manhattan for a bunch of beads. Now, we all heard the story while growing up. Back in the day, the Dutch settlers bought Manhattan Island on a handshake for $24 worth of trinkets from, good old gullible Indians who had no concept of property rights. But that's not quite the whole story. The Native Americans knew damn well what property rights were and had known for centuries before the Dutch showed up. Turns out the Dutch bought the island from the wrong people. It turns out that the Dutch expedition actually purchased Manhattan from the Canarsie Indians, who were based out of Long Island. They only used the island of Manhattan as a convenient place to get drunk, and were by no means the rightful owners That would be the Manhattan Toast.
Well, it's still a convenient place to get drunk.
Yes. So when a bunch of surly Dutch traders showed up and offered to buy the place, the drunken Canarsies readily accepted. Basically, it was an old school version of the wanna buy the Brooklyn Bridge scam, except this one actually worked. So the Dutch bought it from the wrong set of Indians.
Now you know the rest of the story.
That's right. So should have had a written contract. Now, do we all remember Zoe Deschanel? Actress.
No,
Don't know Zoe Deschanel?
never heard of her.
Oh, goodness. She was the new girl in the TV show The New Girl. Okay.
I,
Greg is looking at me like I'm an Indian.
I believe you.
Okay.
I've never heard of the show, but that's okay.
Well, the new girl sued the shoe company, Steve Madden, claiming they never paid up on an oral agreement for an endorsement deal where they would put out a line of Zoe shoes and accessories. To make matters worse, Candies, a brand owned by Madden, released a shoe called the Zoe, which Deschanel claimed infringed on her publicity rights. Deschanel was suing for $1.2 million, but dropped the lawsuit in January of 2012 after receiving several adverse rulings by the court. What were those adverse rulings? I honestly don't know, but I suspect if I dug deeper, I would find that they were on evidentiary issues, that certain arguments couldn't be made, certain evidence couldn't be used, all because this was a oral contract. No Deschanel. Well, you must have heard of Paris Hilton.
Yes.
Okay, good. Because Bruce McInnes, an investment banker, claimed that the sum of 13.5 million pounds was due to him pursuant to an oral contract in which he alleged had been entered into over dinner in a Knightsbridge restaurant with Hans Thomas Gross. And you are quizzical about where this is going. Mr. Gross is an Austrian national and the main figure behind a group of companies known as Running Ball, a global sports data company. Mr. Gross is also known for being the ex-boyfriend, socialite.
Oh, now you're getting there.
Now I'm getting there. Mr. McInnes claimed that it was agreed that he would personally provide services to Mr. Gross with the aim of maximizing the return to Mr. Gross of the sale of Running Ball. In return, he would receive remuneration equivalent to 15% of the difference between the actual sale price of the company and the target price. Mr. McInnes explained there had been no written agreement between the parties because Mr. Gross had told him that he made his deals on a handshake in the Asian way. Mr. Gross claimed, however, that the only handshake between the parties was just to say goodbye after dinner. The court in England found that although it was possible for a binding contract to come into existence over dinner in a restaurant, a highly informal and relaxed setting required close scrutiny over whether there was any intention to create legal relations. The court decided in the case that there was no such intention. Why? Well, Mr. McGinnis was an experienced banker who would have been aware of the importance of having a written contract, and his failure to produce one, or even a draft, was a critical omission. Also, there was substantial uncertainty over the terms of the alleged agreement, and in particular, over Mr. McGinnis's remuneration and the services he was to provide. Also, there was no agreement or certainty as to the actual relevant parties to the transaction. Mr. McGinnis was, at the time, an employee of Investec and therefore not in a position to make any immediate contract with Mr. Gross personally. He could only have contracted on behalf of Investec. And last, although it is possible to enter into an oral contract, it is advisable for the parties to an agreement to seek legal advice and have a written contract drawn up which accurately reflects the terms agreed upon between them so as to avoid any dispute arising subsequently. So essentially, the court in England said exactly what I said at the top of the show. Here's the reason to put something complex and detailed, at least, into writing. All right, now.
Before I signed my NFL contract, I should have shown it to you.
Hey, I'd love it if some NFL player or MLB wants to bring me their contract.
39 pages this year for the Westwood One Monday Night Football. 20 of those pages are commercials we cannot air, and 15 of those pages relate to gambling. Can you believe that?
I can believe that because I had the privilege, on Facebook at least, of seeing several photographs this past week of my stepson from a prior marriage assisting in filming an NFL game.
Cool.
And I saw him behind the camera, and that was a heck of a moment to see that kid that I remember as a 7-year-old who I persuaded his mother into allowing him to play 1 year of tackle football. He didn't like it. He didn't like getting hit, but he still was a football fan, and there he was participating in an NFL game. So that was really something.
So was he working for NFL Films?
No, he actually, depending upon the time, he either works for a company or he's on his own, but he has so many relationships now in sports and with big scale rappers particularly, that they will call him to do various audio video things for their concerts. He's done game shows like I can never remember. I don't watch game shows, the names of them. The one where two families fight each other.
Yeah.
What's the name of that show?
Yeah, I can't think of it, but yeah,
All right. Well,
Family Feud or something like that.
Yeah, he's done a number of those game shows, and as I followed the development of his career over the years, this kid has really done good for himself.
Oh, he's an A-list videographer then.
Yeah, I'm very proud of him. But let's talk about something that most of us can relate to. Buying a new car. Oh, don't we love those contracts, man? Fine print and everything. Well, I will tell you, the ways of negotiating the purchase of a new car have changed when my dad first brought me into a dealership to purchase my first car in 1985. I remember going to the Freehold, New Jersey Dodge dealer. And I remember my father taking me in, sitting down at the salesman's desk. And back then, they didn't have packages. You had to go through extra by extra by extra and build the car you wanted. And if you omitted something, too tough luck. They built that car for you. So you had to make sure things were the way you wanted them. And that means reviewing that contract really carefully. Because if they forgot the automatic door lock, well, then you were manually opening and closing your door. Or if they even had the power window and you chose not to get it, well, then you were cranking that window up and down for as long as you owned that car. And, my father taught me how to buy a car extra by extra by extra.
And you're still driving that, right?
I'm still driving. But then things changed. They started packaging things together. And if you wanted a certain extra, you had to buy a whole package. And then you were saying to the salesman, but I don't want that stuff. I just want this. Tough luck. That's the way the manufacturer was packaging it. So now you had hours in a dealership negotiating a new car. You sat there and you bickered back and forth between price, and your salesman made believe he had to go talk to his sales manager, and he went behind, I don't know, some wall or closed door, and a couple of salesmen laughed together for a while until he came back to you and said, my sales manager just won't approve that. And you're supposed to believe that, et cetera, et cetera, et cetera. You never really knew when they were talking to somebody or when they were just faking talking to somebody. So, at least for me, when I went in to buy a car, I would go in, I don't know, about 1 o'clock in the afternoon, and I would stay to about 9 o'clock at night. And I would talk and talk and talk, negotiate and tell stories, and wear them down as they tried to wear me down. In fact, there was one car I bought in West Palm, and it was about 5 or 6 o'clock, and I decided it was a good idea to take a break. And so I said, well, I'm going to go out and get some dinner, and then I'll be back afterwards. I stood up, I started to leave, and sure enough, they reeled me right back in. Well, what do you want? Maybe we can get it for you. I said, I don't know. Anything, something sweet, something to keep the adrenaline going. You don't want to negotiate when you're falling asleep. So they went back and they brought me out some donuts and they brought me out a box of cookies. That was very nice of them. And so I sat there sugarizing myself and continuing to discuss things with the salesman. And finally, there came a point where he really did need to go to talk to a sales manager because we were getting into the nitty gritty. So he actually comes back with the sales manager who's going to talk to me now and explain to me why they can't do what I'm asking them to do. The sales manager comes over, and before he has a chance to say anything to me, I look at him, I pick up the box, and I say, want a cookie? sort of took the edge off of things. So he takes a cookie. He really doesn't have much of a choice. And we talk further. Now, the long story ends. I don't remember on that particular issue whether I won the point or they won the point. I did eventually buy the car. It was after 9 o'clock. The dealership was closing, and they wanted me to, read the contract. They wanted to get me out of there. So I think they agreed at the end to the last few things just to get the deal done. But that's another way. It evolved from, buying every single item to this type of, well, you want to sell the car to me for $27,410? I'll only pay you $26,327. And now you negotiate dollar or tens of dollars or hundreds of dollars, in increments.
Man, that was really inflation. A $27,000 box of cookies.
That's right. That was brutal. So now, how is car negotiation done today? In my opinion, the right way and the wrong way. The right way these days is to figure out the car you want. You can do that by going to all sorts of dealerships and test driving them and never intending to buy at that dealership. I'm just here for a test drive, just here looking. And then once you've decided on a vehicle, you go back home and you send these messages to the internet department at various local dealerships that you're willing to purchase a car from. Presumably, hopefully, you know how to look on their online site the vehicles they have available. You found the vehicle you want with the packages you want and the color you want. And if it's on their lot, it makes it easier, but it doesn't really matter. If you found the car you really want, it's that vehicle, and it's in Orlando, they'll make arrangements to have it brought in the next day. Trust me. The dealers trade back all the time. So you have found the car you want. You know what the pricing is. Hopefully you've done your research. You know what the pricing should be. You know how low you really can get the deal. And you ask them for their best offer. And hopefully you get a few from a few different dealerships, their best offers. And then you get in touch with them by internet again, by email. You don't even call them. You certainly don't show up. You email and you say, that's not quite good enough. I'm looking for a deal at, and you give them a price that is slightly below what the major magazines like Edmunds and all that say is a fair price. Slightly below. And they communicate with you again through email. They can't quite do that. That's a little bit too low, but they can come down to X. They've now lowered their price. You got them to lower their price by making an offer that was ridiculous. You've got one free move. Now you send another email back and you offer to increase your offer to X. And it's only going to take 2 or 3 moves typically before you're told by the dealership that's the best they can do. My advice, you never accept anybody's that's the best I can do until you hear it at least twice. You go back to them with another proposal, and if you hear again, that was the best I could do, then you can start to believe it, and then you have a decision to make.
All right, Stuart, how do you handle like these car delivery companies that that you see on television now that deliver cars to your house? how does all this stuff work out legally?
Well, it's sort of the same as what I'm discussing with a couple of wrinkles. If you go into the dealership, let's say you've done your internet negotiating, and you go into the dealership to fill out the paperwork. They already are prepared because you've told them deal, and I'll be in on Saturday at 1 o'clock. Then the papers should all be prepared, and the only thing you may have to fight off is the financing and interest guy who tries to sell you all that extra stuff. But essentially, the paperwork should be prepared. You should read it carefully, make sure everything is correct, make sure all the monetary figures are correct, make sure the financing is correct. You don't let them slip it by you at that point. And then you can also negotiate, and they expect it, your trade-in if you have one. And the great way about doing it this way is they're not mixing the price of the trade-in and the price of the new car. You've already agreed upon the price of the new car. Now, when you come in with the trade-in, you know whether or not you're getting a decent price for your trade-in, because they're not inflating it and then taking it back on the price of the new car. You've already agreed upon that. Much better way to negotiate. Two completely separate transactions. Now, to get to Greg's point about these new car delivery services, well, they basically operate in this way I describe as internet pricing. You find the car on the lot that they have, you're interested in, and you negotiate either by email or by phone back and forth on the price. Once that's agreed upon, they prepare the paperwork. Now, I would suspect they probably send you the paperwork ahead of time, because the truck drivers, the car carriers, they don't want to sit there while you're reading a contract. I'm not sure about this, but I suspect the written deal is completed before they bring you the car. And once you've signed off on the written deal and it's been exchanged, most likely via email, that's when they send you the car, and the car is offloaded, and you're given the keys and whatever other title or plates or manuals that come along with it, and they drive away and you have your vehicle. That is my assumption. So I think that's the new way of purchasing a vehicle. In fact, it's the way I purchased the last two vehicles. And I think that lessens the power of the salesman, because they don't get to keep you there, make you wait while they pretend to talk to other people, and keep the pressure on you, because the longer you're there, the more you have invested, and the less likely you want to get up and walk away. But if you can do it all from the comfort of your couch, then you have the advantage, not the salesperson.
It was interesting at the broadcasters convention, though. This is a few years back. One of the vice presidents of Ford was talking about by 2035 that the dealerships per se would be like service centers. And it's like what you're saying, almost everything else would be done on the web, and there would really be no sales part of a dealership anymore. And that, of course, that's years away, but still, that's
it's nice to know that that's what they think the model is looking like, because I think that's where the model is trending more and more. Now, there are some of us older folk who are not quite internet savvy and still want to go into the dealership to negotiate. But the reality is, by 2035, well, those older folk will be gone. I know, for example, my father, who, as I said, first taught me how to buy a car. And then that model of purchasing changed. He would not have been comfortable using the internet to negotiate a car. He would have to go in and touch it and feel it and look the salesman across the eye. Of course, my father was a salesman too. And he would have had to have done it eye to eye. I don't think that's the best way to do it. So my father and I would have differed. I like it when they get to me by email with a price, and they're waiting for my response. I like it when I have that power and they never get to see me unless the deal is done. So if the model is trending towards the dealership being more of a service center to process the vehicles as opposed to a sales center, I think that's good for most of us, as particularly our kids who do everything, not even by computer, but by phone. They are the ones who are going to be purchasing these cars via phone and comfortable doing so. We may not all be there yet.
But how do you test drive a car on the web? You can't.
Well, you do the next best thing. You go, let's say, to, I don't know, US 1's Ford dealership if you're buying a Mustang, and you test drive one of their Mustangs, and you see, do I feel comfortable in it? Do I like the pickup? I can play with the options. And if I'm trying to decide between a Mustang and a minivan, I can go test them both. I can drive them both. And I'll be honest with you, I'm a big guy. And, not all vehicles are comfortable for me in what they now call the new front seat style, which is the cockpit, where there's a middle there, so that if your right knee likes to lounge around, it can only go so far before it hits a solid object. And that makes certain vehicles more or less comfortable for me. So when I am deciding on a new car, I am test driving several, in particular to see how do I feel in the front seat, the driver's seat of that car. And that is no small issue for me in making a decision as to what I'm going to purchase. And so when I have found something I'm comfortable in, something I like, something I'm willing to purchase, then I'll start the process of going home and sending out emails to, internet department of all these dealerships. And they all have internet departments now. And I'll get responses. And then I'm comfortable negotiating. Now, if I happen to pick up a vehicle which feels funny or something, I'll bring it in. I'll make sure that it's very quickly notated. And, then you deal with, most likely it's going to be fixed very easily. But if you have a lemon, the lemon law applies, and you have to take it in X number of times and give them X number of attempts to fix it until they have to give you a new car. So I don't worry about that much because I have found, again, back in the old day, what would happen is the car would be delivered, and within a week, you'd have a list of a dozen things that the dealer needed to fix. Now I have found the car is delivered to you, and if anything needs to be fixed, it's one, two things. That's it. The cars seem to be delivered for the most part pretty well assembled and operated. At least that's my experience. Oh, so time is running. I'm gonna skip for a second to get to a particular topic that I had to deal with last week. Some people go into these fitness centers and they sign up for a membership. And sometimes, it's a very expensive membership. And they come home and the contract is not what they thought. Or upon reading the contract more closely, it has provisions they didn't expect. Same thing goes for a contract. You've signed up for a membership and you've asked somebody to show you how the equipment works. And the next thing you know, you're sitting down with somebody offering the services of a trainer. And you're negotiating a contract for how many times a month or how many times a week, and how much is it going to cost, and how much down, and all that stuff. And sometimes you never intended to have a contract for a trainer, but it just seemed to happen. And other times you may have wanted a contract for a trainer, but if you didn't read the contract while you were there, you might come home with a contract that doesn't say what you thought it said. For example, you agree on a contract for a trainer essentially once a week, 4 times a month. And you agree upon a price, and you agree that it's going to be a 6-month contract. They wanted a year, but you negotiated them down to 6 months. It's late in the evening. You want to get home. They go to print out the contract. Oh, and by the way, you didn't sign the actual contract. They showed you a computer like they do when you sign in for the doctors. This is consent to treat you. And you just sign that little pad.
Yeah, they're all doing that now.
You don't know if you signed, giving up your kidneys, but you signed that pad for consent to treatment. So now what you're shown is various places on a computer screen. Initial here, initial here, initial here, sign here, sign here, sign here. You don't see any print. You're just told where to initial and where to sign. And they're explaining to you as you go along what you're initialing and what you're signing. Now, they could be honest about it. They could be dishonest about it. They could be wrong about it by error. So anyway, then they go to print out your copy of the contract with your initials and your signature. And you take it and you go home. Wrong. You should take it, sit down, and look at it. Look at the terms, make sure they're the terms that you agreed upon. Because what happens is you take it home and you find that it's not a 6-month contract, it's a year. You don't get 4 sessions a month, you get 3. And what are you supposed to do now? Oh, there's this little provision that you can cancel within 3 business days, excluding weekends and holidays. So now you call to try to solve this problem, and you get put off, and you get put off, and you get confusing language, and we'll fix this tomorrow. Well, it then turns out that tomorrow is after the midnight deadline for you to cancel. And if you listen to that salesman and you go in tomorrow, you are probably going to get told, this is what you agreed to. And they're going to have you over a barrel. Unless you're able to prove fraud or negligent misrepresentation, that contract is going to be binding. So I had a situation with a client where they had this precise thing happen to them, and I had to persuade them to bring, because it was too late to mail, to bring that evening a letter of canceling the contract to that particular fitness center and hand it in and try to get somebody to sign off on receiving, a copy of it. I was told they could also swipe their card, and that would be proof that they were there at that time, which was helpful as well. And the letter that I had prepared for them said, I'm more than happy to come in tomorrow and work on negotiating, the contract we agreed upon. But I have to cancel this one because I'm going to run out of time. Well, they canceled it, and crickets. Don't hear from anybody. Which means now I've got to write a lawyer letter threatening to sue for breach of contract, fraud, negligent misrepresentation, and violation of the Florida Unfair and Deceptive Trade Practices Act. That'll be fun. And it's time to say farewell. So, on this Labor Day weekend, have a lot of fun. Don't go into labor. And I will see you again next Friday for Ask a Lawyer. Take care.
You've been listening to Ask a Lawyer on WSTU, Stuart, WPSL, Port St. Lucie.